Well, who it is when as Schwab says, we won't own any property. Who is it that's going to own the property, Mr. Schwab? Isn't that the question that needs to be asked? Can you name the individuals, organizations, corporations, whatever they are, who will or which will actually own all of this property?
This is Kaiser Johnson with Liberty and Finance, and these are the Miles Franklin Weekly Specials for January 29th through February 5th, 2024, while supplies last. This week we have silver Valcambi or Asahi 100-ounce bars at just $1.39 over spot per ounce. We also feature pre-1933 gold $10 and $20 Liberties at $89 over melt and $139 over melt, respectively. Next, backdated 1-ounce silver maples are at $3.75 over spot with a minimum order of 50. To order our specials or any of the many other options we have available, call us at 1-888-81-LIBERTY. That's 1-888-815-4237. We're available after hours and on weekends, and we look forward to speaking with you.
Welcome back to Liberty and Finance. We are privileged to have this distinguished returning guest. Dr. Edwin Vieira is a constitutional attorney specializing in constitutional law and as an author of books about constitutional money, solid currency such as gold and silver, as well as giving us a lot of information in the past about the Second Amendment rights and the true roots of the militias of the states, etc., rather than some of the misunderstandings that circulate around that topic. Today, we'd like to address with you, Dr. Vieira, the topic of private property rights. There's a lot of reason that people have concerns around that. We'll get into that in just a minute, but first I just wanted to give you a chance to welcome you here to Liberty and Finance this Thursday, January 25th, 2024.
Well, thank you very much. My pleasure to be with you.
When I reached out to you, and thank you for agreeing to come on and give us an education about this important topic, perhaps this is arising from many different areas that people have noticed in the news or perhaps in stories that they've heard, anecdotes from acquaintances, etc. But there's growing concern among our subscribers and among people in general about private property rights. We've heard of civil asset forfeiture incidents where people are concerned to be carrying either cash or precious metals, for that matter, in their car, for example, if they were to get pulled over for some routine stop, that they might have to give up their property without due cause, which you'll inform us whether that's constitutional or not. Also, there's geopolitical examples. We had a rather glorious example a couple of years ago in Canada with the Trucker Freedom Rally, where Prime Minister Trudeau seized bank accounts not only of truckers, but anyone is thought to be supporting of truckers. And that has just recently come back into the news because a Canadian judge has just struck that down as being illegal action on his part, and that's getting appealed. We'll see where that goes. Also, there's a proposed seizure of Russian and other financial assets related to the Ukraine conflict, and the proposal that they even be used, those assets taken by the West to the Biden administration, saying we're going to use those to rebuild Ukraine. There's also concern about government seizure of farmlands, both in the Netherlands, where there's been significant pressure from the government trying to shut down farmers and saying that this is in the name of preventing climate concerns by reducing the greenhouse gas footprint of cow farming, that sort of thing, and modern agriculture, as well as in the U.S., where the Biden administration has announced goals for 2030 and 2050 of increasing dramatically the percentage of the United States land area that would be owned and protected and basically held out of public use. Teaching farmer Joel Salatin, whom we've had on, has called that protection by abandonment of the ecosystem. And I guess you can sum up all of this perhaps in no more succinctly than in the statement from Klaus Schwab of the World Economic Forum, who has famously recently been quoted as saying, "You will own nothing and be happy." Many people are very concerned about the prospect of a future in which they own nothing, or their children, or their grandchildren. They are accustomed to believing that the people have a right to the fruits of their labor, and that they have constitutional protections against illegal search and seizure, and so on, and wanting to know if they really own their home and their land, and do they really own precious metals that they may purchase or other assets that they have, or are we entering a dystopic future in which all of these things can and will be taken away from us, and we'll be dependent serfs, sort of as in 1984 or The Hunger Games or Soylent Green or whatever, these dystopic movies or books that have portrayed a future in which there are basically two classes, a very small elite class and a very large class of everyone else. There's a lot to unpack, but this is the topic of concern, private property rights in general, and the trend and the direction of where this is heading in future, and perhaps whether we can do anything about it in the end. And I'll unleash you on that, and happy to weigh in wherever my additions might be useful. But thank you for joining us on that topic.
Well, this is a very open-ended topic because of the nature of property rights. Property rights entail not only titular ownership, but use and benefit, or to some extent, what's called waste, right? I may own a very large lot that's just forest, trees, and some developers want to build a Marriott Suites or some other hotel on it, and they're claiming that property is not being used to its highest potential economic value within the particular area. And so they're saying, well, this is just essentially waste property. I'm holding this outside of the economic process, and therefore that somehow is an improper use, or they would call it a misuse of property. So you get into all sorts of problems along that line. Where we are now goes back, I think, to Benjamin Franklin's supposed statement when the lady asked him as he came out of the Constitutional Convention, what have you given us, Mr. Franklin, Dr. Franklin? And he said, a republic if you can keep it. The reason we have these problems is because there's been incremental inroads on the very concept of property, and certainly the enjoyment and use of property over many decades. I can think about this in my own existence going back to the 1950s, can remember these situations. And people have not stood up against it. They've allowed this to go on with a certain amount of muttering and, criticism of the politicians, but there has been no definitive movement. And I suppose it's because it's been done incrementally until you get to a large group, such as the farmers, who all recognize a community of interest. You're not going to see decided political opposition. But let's go to one of the classic examples of this, which is, in terms of constitutional misinterpretation, eminent domain. Eminent domain is a concept that private property can be taken from the titular owner entirely for public use on the payment of just compensation. Just compensation supposedly being the present market value of that property. Which is a fascinating concept in itself of what you're talking about, present market value. But if you look at the situation of the government in Washington, what they call the federal government, national government, the courts have said, well, the national government has a power of eminent domain simply because it has certain sovereignty, this inherent sovereignty. Well, that may be true of the states because how the states' history derives from their position as colonies, which derived from their position as part of the British Empire, and eminent domain, this concept that the state has ultimate claims on the land, goes all the way back to the Norman conquest, right? When the Normans claimed that as a result of conquering England, all of the land of England became the property of the new king. Right, but that isn't how the government in Washington was created. It wasn't created in the sense of, or evolved in the sense of being an direct outgrowth of the so-called sovereign authorities of the British king, and then eventually the colonies, and eventually the states that declared their independence. It was a creation kind of Frankenstein's creation put together of parts. And those parts are defined by the Constitution itself. So if we ask, where would we find eminent domain as a power in the Constitution? Well, we look at the actual delegated powers of Congress, it's not there. It's clearly not there. And if we go to the amendments to the Constitution, it's not there either. In fact, quite the opposite. Private property shall not be taken for public use without just compensation. That's a provision, but does that apply to the government in Washington? It clearly applies to the state governments. There's a limitation of just compensation for them. But if you look at the powers of Congress, which is where this is supposed to arise, Article 1, Section 8, Clause 17. All right. Congress is given the power to exercise authority over all places purchased by the consent of the legislature of the state in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Well, there it is. There's the power of Congress to obtain property outside of what's called the 10-mile square. That is, now it's a District of Columbia, but it isn't 10 miles. I mean, they're not even following the constitutional requirement there. But Congress is supposed to go and purchase those properties with the consent of the legislature of the state in which the same shall be. Saying that there's a limitation on that power of purchase in the hands of the state legislatures. So what could we imagine would be a situation where Congress comes to a state and says, listen, we need a certain amount of property here to build one of these forts, magazines, arsenals, dockyards, and needed buildings. And the legislature said, well, that's a good idea. We're going to give consent to that. You can purchase that from us. But we're first going to take it from our own citizens by the eminent domain power that our state has to take private property for public use, and we can take it for public use on behalf of the national government because of this provision. Is that what happens now? And the answer is no. National government just goes and exercises eminent domain wherever it feels like doing it. So that's problem number one. They've already stepped outside of that narrow limitation or control mechanism on the ability of the national government to obtain control over private property within the states. Then you think of all the territories or portions of states, Nevada, Arizona, these western states where large segments of the territory of those states is still controlled by and claimed to have ownership interests by the government in Washington. Department of the Interior is running all those places. How do those things come into being? Well, they were part of territories way back when, and states were carved out of those territories. Nevada, Wyoming, Kansas, Nebraska, all of the western states. And there was a provision made when one of those states came into the Union for the state to continue to allow this territory to be owned by the national government. That was a contingent proposition. Probably that's unconstitutional too. They couldn't impose a condition on those new western states that had never been imposed on the original states. So we're dealing with huge swaths of property that the national government shouldn't control at all. The state government should control it, one way or the other. And then, of course, we have the question of public use. Look at any of these eminent domain cases, the question is there public use? And the Supreme Court, once again, the Supreme Court has followed this up in so many ways, it's a rat's nest. They held in a case in Connecticut that it was a local government taking property, private property from homeowners, as I recall, to be given to a private developer. And I can't remember whether it was shopping centers. I think it was a shopping center, but it could have been a hotel, whatever. But it was a private operation that was going to use this land taken from homeowners. And the argument was, well, there will be a greater economic benefit from the use of this land for the private developer because the tax base will go up. The value of the property will increase because we'll be using it for activities that will draw in more revenue subject to taxation. And the Supreme Court says, oh, well, that's okay. That's a public use. And of course, if that's true, then there's absolutely no limit on the taking of property, quote unquote, for public use and turning it over to some corporate entity that is the favorite of the local politicians. Because in almost all of those cases, they could claim that there would be some increase in the tax base or the returns to the locality, to local government. So already we're in a situation where you're looking at dispossession as being a matter of simply word games that are played by the courts. And of course, then you get into the question of just compensation. Well, what's the just compensation? Right? If I were to sell, let's say I've got a homestead, right? I've got 5 acres, let's say I have, and this developer wants to buy that land. Well, I could negotiate with him for a much higher price, potentially, than the real estate value of my property if it was sold for a home, the assessed value of my property as a home. Right? And I could negotiate with him maybe double the price, maybe triple the price to myself. And would that not be just compensation? Well, it's the result of a contract. So by hypothesis, it's just compensation. But it would give me leverage in that situation to get the best possible value for my property, the use value for my property. Right? But now the government comes in and says, oh, no, we're going to take this for the real estate assessment tax value, which is lower than I could negotiate with the developer, and then turn it over to the developer so the developer will gain a windfall here. So you look at that and you say, well, there's another aspect of the fraud that's going on. We're not giving just compensation, because the compensation will be determined by the agency that determines it, ultimately some court. They will be looking at this land value, not in terms of what I could negotiate, but in terms of what I could sell this house for in the regular real estate market. So the whole thing is phony from the word go. All right, there's a problem. And then, of course, we have a massive, I don't know how you'd put this. It's a chaos of regulatory interventions on the use and benefit of property at every level, local level, state level, national governmental level, with various agencies, sometimes with overlapping jurisdictional authority, who can step in at any time. Environmental Protection Agency, Corps of Engineers can step in and say, oh, there's a puddle on your land. This is wetlands, and is now subject to regulation by the Corps of Engineers or the Environmental Protection Agency. And if you don't spend hundreds of thousands of dollars building a dam or something, or drainage, whatever, then we're going to be fined every day, and eventually the property will be seized. So you look at these situations and say, well, really, what is the remaining concept of property in terms of use, non-use, economic benefit, or personal benefit? Right? I think I'm living in a home. I'm deriving some economic benefit from living in the home as opposed to living in a motel or something. But the main benefit I'm deriving from it is living in, on my so-called 5 acres with the beautiful woods around it, etc., and having a pleasant life in my retirement, my golden years, right? That's use. But they can take that use away from me as well, right? And regulate exactly certain aspects of the use of my property. So how did all this develop? Well, it developed incrementally. A little court decision here, a little local regulation there, eventually the creation of something like the Environmental Protection Agency by Nixon out of nothing. One asked the question, what is the constitutional basis for the Environmental Protection Agency? Article 1, Section 8, where is it? Can't find it, but it's there. And it now comes and regulates things that are completely local in nature, have no relationship, for instance, to commerce. Right? The amount of water that may be on my property when I get heavy rain has nothing to do with commerce. So how are they regulating this entirely local activity? How is the Corps of Engineers coming, for instance, to tell me that this is now wetlands? Because 5% of the year it has residual water from rain that is only slowly draining. Right? The Environmental Protection Agency telling me that this is a place where some green frog might habitate. and therefore I'm subject to all sorts of regulations. It's an insane, crazy quilt of regulatory authority because, of course, when statutes are passed, the legislators do not look back at the entire core of the code, U.S. code or state code, whatever it may be, to see what the potential interactions of their new statute would be throughout that code. They might look at the amendment of some earlier statute that's in kind of no historical line, and they don't look at the implications potential of putting this in. So let's take an example that you mentioned, which is seizure of property, forfeiture laws, so-called. Well, where do these forfeiture laws come from? And the court will say, well, they come from Old English law, especially dealing with customs and so forth, where they could seize things that were being illegally imported. All right, contraband, so-called. Well, one wonders what happened to that concept when the Fourth and Fifth Amendments were enacted. Fourth Amendment, right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Right? Secure in their persons, houses, papers, and effects. Well, that's effect. That's essentially everything that you might own. Right? Against unreasonable seizures. And no warrant shall issue but upon probable cause, supported by oath or affirmation. So you take a situation where the state police in some area where they consider that the main highways are part of the drug trafficking network, and they stop a car, not based on reasonable suspicion, but based on profiling, out-of-state car, about, a black man and a black woman are in the car, drugs, okay, we stop the car on some pretext, headlight is out or whatever, and then they search the car and they find $15,000, which the couple were using because they were going to go to the next state from Virginia, North Carolina. They're going to buy furniture and try to get the best home furnishing to try to get the best possible price by paying in cash. All right, they're refurnishing their first floor of their home. And the police say, oh, well, drug proceeds, must be drug proceeds. You're driving on a drug highway, et cetera, et cetera. So we seize this property. And now it's for you to go into court and, in a sense, prove your innocence, or prove the innocence of the property, because the case is always whatever, state of Tennessee or versus $15,000 in cash. That's the way those cases are captioned, right? And so you have to go in and do that. Well, what happened there to probable cause? Supported by oath or affirmation, describing the place to be searched and the persons or things to be seized. They didn't know the $15,000 was in that car. They had no way of stating probable cause, supported by oath or affirmation, that these two people in that car were likely drug dealers. They had a long record, a yellow sheet of drug dealing, that they had just been seen leaving a house that was frequented by drug distributors. They had nothing like that. Right? Some kind of a guess. And then what do they do with the money or the car or whatever it is that they've seized? Well, it goes into the general fund of the police department. It goes into the general fund of the county government, maybe the state government. And everybody knows, it's notorious that this is simply a looting operation. Everyone in the country knows this. I can't imagine that the courts don't know this. And why hasn't this gone to the Supreme Court? The Supreme Court threw the whole thing out. So we've got a Fourth Amendment. We don't care what the customs laws were in England or the colonies when colonies were part of the British Empire. We have Fourth Amendment comes in and says you have to do this. You can't touch a person's effects, seize a person's effects without the following limitations being accepted, right? Otherwise, it's unreasonable by definition. It's unreasonable to look at some money and say, this must be drug proceeds when you know nothing about the people, the money, et cetera, et cetera. It's an absurdity, but there it is. And we're talking about hundreds of thousands, if not millions of dollars worth of cash and property seized in this country over whatever period you want to go by, 10 years, 20 years. It's a huge amount, okay? And it's amazing that the legislatures, Congress, or the state legislatures don't outlaw this. Why? Well, because they're in bed with the prosecutors and they're in bed with the police departments. It's all a big racket. And then, of course, you come to regulation of use. An individual may continue to have the title to the property, but he may be stripped of beneficial uses. Now, of course, always say, well, he's completely stripped of beneficial uses. You can't do anything with it. Then it becomes a taking, right? And taking for public use. Well, what's the public use? Compliance with the regulation. See the circle that's built in here. They create a regulation, which may or may not be valid. Then they call that a public use as soon as that regulation strips an individual of total beneficial use of his own property. So again, we're in one of these legal logical circles. But we have a mass of these regulations that go back to the COVID era, which we now know. We knew it then, anyone who was actually paying attention. But we now know the basic, let's not say fraudulence, fictitious nature of the pseudoscience that was put forward on the basis of lockdowns and the rest of that nonsense that they went on with. Entirely fictitious. I mean, the lockdown thing, people knew the lockdowns didn't do what they thought they would do anyway, let alone COVID. We didn't need to find out later on, right? But they did it anyway. Well, what happened during those lockdowns? The beneficial use of property was stripped from the titular property owner, or perhaps the rentor, or the lessee of the property. You're running a restaurant. You may not own that building, but you have beneficial use of that property because you're leasing the building for your restaurant. And that's the use. And through that use, you gain income, we'll assume. They come along with this regulation based on fictitious pseudoscience, not even science, not even pseudoscience, fictitious regulation. They shut you down. Now you've lost the benefit of that property, which is the lease, to use the physical property. Right? So we're not even talking necessarily about physical property. We're talking about these other aspects of property rights. And what's happened there? Were those people ever compensated? If you said, well, that was a public use, the seizure of that property and closing of that property to the lockdown was a public use because of this supposedly hyper dangerous Black Death type infection, which we now know was entirely baloney, and which they knew now. At the time, they knew it. So he's lost the use. Where is the just compensation? Wasn't the private property taken for public use? Assuming all the rest of this COVID nonsense was true, the public use, there was the public use, where's the just compensation? Well, that's an interesting question, isn't it? So now we've seen a situation where they take emergency regulations, by the way, which have no constitutional legitimacy whatsoever, use that as the basis for seizure of property, in the sense of the use of the property at least, supposedly for this public benefit, this public use of increasing the likelihood of preventing people from being infected. And okay, fine. So it fits that paradigm so far. You've gotten to public use. Let's assume all that's true. Where's the just compensation? Well, it isn't there. How many trillions would they have to pay for the just compensation for all those people who lost business or were eventually driven out of business entirely? Okay? So we look at this and we say, all right, well, what are the actual property rights you have? And in the concept of right, which gives the other side a duty to recognize your right, not infringe on it. And all of these supposed protections explicitly written into the Constitution of the United States, and the Constitution of many states have the same types of provisions. And they've been held to be applicable to local governments or these development agencies, anything that has some kind of state imprimatur, and even to private developers who collude with local government to essentially steal people's property for their own economic advancement. Well, where is it? Where's the enforcement? A right without a remedy is not existent. That's a basic principle of law. Every right must have some kind of remedy. And ultimately, the remedy must be against the person that is, or entity that is violating the right, which in this case is always some governmental entity, which is seizing property, regulating property, the whole panoply of interference that you can imagine. And then, of course, we have the fascinating concept of Mr. Boutros, whatever, Ghali there, in the WHO, coming up with this pandemic treaty, which seems even more open-ended in terms of inroads on property rights than anything we've seen, in the history of the United States, as bad as it is here. And that thing is supposed to, according to the UN, that's going to override all local, national law. So you won't necessarily have even these titular protections, these paper protections. Now, of course, there is a problem with that, that the Constitution cannot be overridden by a treaty. I don't know how many times the Supreme Court has ruled on that. If you accept ruling to the Supreme Court as having any significance. But again and again and again, they've said, no, treaties do not override the Constitution. A treaty may override a state law that's contrary to the treaty, but it can't override the Constitution. Okay. But we know that the people who are supposedly enforcing the Constitution in Washington are perfectly willing to go along with all this nonsense. They did it the last time around. They did it domestically. So they're perfectly willing to go along with what the World Health Organization wants to do. And theoretically, the states could not stand up against this because of the supremacy clause if it becomes a treaty. So then all of a sudden you have the World Health Organization determining all of the property rights of everyone in every one of the 50 states, with the people in the government in Washington looking the other way because they like the result. Well, that's fascinating. So that brings you back to the interesting Declaration of Independence question. Well, now the states are put in a worse position than they were when they were colonies under England, under the king, because that was only one tyrant. Now they're going to have the tyranny of the United Nations telling them what to do. Well, okay. That's a fascinating proposition, isn't it? So one would look at this and say, from the point of view of practicality, do you have any property rights? Well, I don't know. I think clever lawyers can find a way around any kind of property claim that you might make if the government comes at it from the right angle of attack. There's nothing. All right. And Mr. Schwab, you will own nothing. You will be happy. Well, I don't know how happy you'll be. I mean, well, I don't know. Given people who are educated by the National Education Association Teachers Union from kindergarten through the end of high school, they'll probably be happy. I mean, they're morons, so they'll accept anything. Be as happy as my dog is happy. My dog has no property; he's perfectly happy. Right? As far as I can tell, at least he doesn't. He hasn't tried to sue me or something. But I mean, you'll be in that position, of a pet. Right? You'll be happy in the same way your dog is, your cat is happy, or your parakeet is happy. But if you don't own it, who will own it? See, the interesting thing is, all property is owned by someone. Even if we talk about something, a corporation, well, the corporation is owned by the stockholders. So you can say, well, that property, all the GM's plants and so forth and so on, are owned by these, 6 million people who own GM stock. There's always an owner somewhere. There's an unowned property. We may have a difficulty finding the owner because, the old lady died and she didn't have a will. And we have to search for the heirs if there are any. And if there are no heirs, then, as the expression goes, heirs chiefs to the state. The state takes it over because there's nobody else to take it over. So it may be a question of who it is, but it's always somebody. Well, who it is when as Schwab says, we won't own any property. Who is it that's going to own the property, Mr. Schwab? Isn't that the question that needs to be asked? Can you name the individuals, organizations, corporations, whatever they are, who will or which will actually own all of this property? Well, now let's look at something that they want to own in particular, farmland. And they have two mechanisms here. One is taking farmland entirely out of production. And I think that's the depopulation route. That's number one. And then number two, farmland being bought by the right people or the right corporations, Bill Gates, buying huge amounts of farmland. What's he going to do with that farmland? How many tomatoes and cucumbers does he need to grow? How big does his garden have to be to feed, even the guests that he may have over the course of a year in his mansions? Why is he buying millions of acres of farmland? What's going to be done with that? Oh, well, my goodness. If you own farmland, then you own food. If you own food, then you control basically everybody, because basically everybody needs to eat unless you're cannibal. So you look at the picture. This is what's going on. Anybody can see that. Why are they driving the farmers out of business in the Netherlands? Why are they driving them? What's going on there? Germany. Germany's great problem. The reason the Germans, one of the main reasons the Germans didn't win World War I, and probably World War II as well, but World War I certainly, was they were starved out by the British blockade. They couldn't feed themselves. Grave difficulty. Well, you would think with that history, the Germans at least would say, well, wait a minute, we want to be as close to food self-sufficiency as possible. We've been starved out before. But no, because their politicians are obviously working in the interest of someone other than German people. And for some reason or other, German people who used to be perspicacious and educated and so on and so on are so bloody propagandized and stupid that they don't realize this. As well as the fact that their political system, electoral system and so forth has been so rigged that it's probably close to impossible to change the composition of their major governmental authorities. I mean, anyone who questions whether the Netherlands should have sufficient farming to be capable of feeding themselves, that's far right. That's a far right concept. Now, food is now a far right concept. And people listen to this. I mean, think about it. This is not hooted down and laughed at. They can actually put this out in the mass media across the world, not just in the Netherlands, but across the world. This is a far right concept that there should be farmers producing enough food to feed the people. So the political difficulty here is the thing that really controls. You have all these institutions that are perfectly willing to go along with complete misinterpretations, malignant interpretations, if you will, intentionally false interpretations of the constitutions which these individuals have taken an oath to support. Right? So they're all perjured, every one of them. Whether they know that they're violating the oath or they don't care whether they're violating it, it's the same thing. Reckless disregard of the facts, willful indifference, it's the same thing as intent. It's called constructive intent in the law. Right? So you have that, and I don't know how you get around that, given the political party structure. Go back to George Washington. What did he say in his farewell address? He really warned the American people that the spirit of party is very dangerous. He could have called them factions, because that's actually what they are. That's what Madison called them, factions. Factionalism is extraordinarily dangerous. Factionalism has taken over the country. And the factions are headed by these one and a half political parties. I don't consider the Republican Party really a separate party, half of a party. The other half is just a shadow of the Democratic Party. And what are they doing on these fronts? I mean, the seizure of property through forfeiture is one of those things that always struck me as absolutely simple. I always saw that that's a statute. That's all. You can't do this anymore. And if you do it, it's a criminal offense. That ends it. It's gone. Why wasn't that done? When the Supreme Court came out with this idiotic decision that private property could be taken and given to developers, corporations, simply because it would increase the economic value of the property. And there we go again. Economic value in what sense? Economic value to a homeowner is different from economic value to a hotel operator. Why does one override the other? Well, it was always the concept of public use. It was for use by the public. In general, you build a road, you build a bridge.
Is this related, in your view, to FDR's justification and rationale for nationalization of gold in 1933, when he said there was propaganda or there were messages put out there saying that the Depression was being made worse by people who were hoarding money and keeping it out of circulation so that it couldn't help the economy to thrive and flourish, and therefore they were the public enemy, and the people needed to turn in their gold to the government so that it could be put to use in redeeming the economy.
Yeah, okay. It could be put to use by inflating the paper currency, because the paper currency could not be redeemed in gold. See, the circle was nonsense on the face of it. They grabbed the gold. What did they do with it? They melted all the coins that they obtained, which wasn't 100%, but it was around 50% of the coins they thought was out there. And they melted it into bars and put it in Fort Knox at the time, somewhere else now probably. And those bars were called coin melt bars. They weren't the 999 purity gold bars, bullion bars. They were coin melt bars. Well, there were no more coinage. Supposedly, it was all taken out. Well, what did that have to do then with the amount of money in circulation? The amount of money in circulation was bank credit or paper currency or silver coinage. They never did seize the silver. Why did they seize all the silver in the world? In the United States, at least. Or the junk coinage, because they had nickels and pennies, cents. So the whole thing was nonsense. But who failed to stop it? Let's once again go and look at what happened. Out comes this nonsense. And did the Supreme Court say, oh, well, you can't seize this property? You have no justified public use for seizing the coinage of the country, which the Constitution requires Congress to provide to the people? That couldn't be a public use, to seize from the people the very coinage that the Constitution requires Congress to provide? Little circle of logic there, one would think. What happened there? Did the Supreme Court ever decide the constitutionality, or let me put it the other way around, the unconstitutionality of the gold seizure? No. Why not? Because it was a fraud perpetrated. There were 3 cases, actually 4 different parties, that dealt with the abrogation of the gold clauses in contracts. Clause that required that payment be made in gold. It could have been made in silver. They called all those contracts gold clauses. And those cases came to the Supreme Court. And interestingly enough, none of the litigants challenged the gold seizure. They didn't say we were entitled to have these contracts enforced as they were written and to be paid in gold. They said, no, we don't care about the gold seizure. We want to be paid in the paper money value of gold, because, of course, Roosevelt and Morgenthau, Secretary of the Treasury, were day by day purporting to increase the paper money value of an ounce of gold, eventually up to the famous $35 an ounce. Now, one would look at that and say, wait a minute, the key to the whole thing is the seizure. The reason these people are having a problem with the contracts, their gold clause contracts, is that they can't obtain the gold that the contract requires them to obtain. And if they obtain that gold, they wouldn't have to worry about what Roosevelt does in purporting to raise the price of gold, because they'd have the gold at the higher price, whatever the higher price was. So any lawyer with sense would say, well, we have to challenge the gold seizure. That's point number 1. And if we were to lose on that, then we have points number 2, 3, and 4, whatever. and try and get some other kind of relief. But number one is to challenge the gold seizure. Did these people challenge the gold seizure? No. In fact, they make a point in the papers they file with the Supreme Court that they were not challenging the gold seizure. And the Supreme Court itself, in its opinion, says, we're making a point that no one's challenging the gold seizure. And even the dissenters, the 4 dissenters in that case, make a point in the dissent saying, no one's challenging the gold seizure. So I scratched my head many years ago and said, how could that be possible? So when I looked and go through all of the petitions that filed with the Supreme Court in that era, and you really have to look because there's no index and table of contents. They come in the Supreme Court and after they get a certain number of them, they bind them, leather binding. And so you have to look through every one of them because they don't necessarily say on the face, this is a gold seizure case. It could be United States versus Jones. It could be Smith versus whatever. Right. You have to open each one up. What are the questions presented? What are they challenging? Well, there was one fellow, this lawyer from New York, and he had, I think it was $200,000 worth of gold bars in one of the big New York banks. And when the Roosevelt gold seizure came out, the banks were required to report. And this fellow had a safety deposit box. I imagine it was insured. And so he had to disclose to the banks what he had in the safety deposit box. They knew he had the gold. The bank disclosed that to the Treasury. The lawyer didn't disclose it to the Treasury. So the Treasury shows up. They grab the gold. They go after him for failing to disclose. He's got a criminal charge against him. So he's fighting all these things. Goes all the way up to the Supreme Court. Filed a petition for certiorari in which the gold seizure was the issue. And at a conference that the court has, they'll have these conferences on a regular basis, and they will consider a number of petitions that are in front of them, maybe other things as well. And the same day that they were considering one of these gold clause case petitions, they were considering this lawyer's petition on the gold seizure. The same day, at the same table, the same 9 people. And one would have thought that those 4 dissenters who were so adamant in their opposition to what Congress had done with respect to the gold clauses, when they had that opportunity, would have said to the whole court, we have to take this case by this New York lawyer because this is the only one that's raising the gold seizure, which is the predicate for this other stuff we have in front of us. And the rule at that time, which it still is called the rule of 4. When a petition is presented to the Supreme Court, it takes only 4 people, 4 justices, to require that petition to be heard. And it may turn out that one of those 4, or all those 4, rule against the petition on the merits when it's finally heard. But they may say, this is so important, we have to have it heard, whatever the result is. But in this particular case, I would have thought that the 4 dissenters would have said that the gold seizure was unconstitutional. So it's fascinating as to why they didn't do that. And then when they write their opinion on the gold clauses, they make such a big deal out of how, this is such a breakdown of faith by the government, this is so terrible, blah, 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 all the crocodile tears. When they were capable of raising the issue which the litigants themselves didn't want to raise in those gold clause cases for whatever reason. I always thought that was malpractice. All right, but there it was. So you go back and if you're willing to look, I think in every one of these instances that we've talked about, you will find that the Supreme Court is responsible for this mess. There's something they've said somewhere. I take eminent domain as a classic example of this. Way back when, I think it was a Marshall opinion. It may have been the Baltimore case, Baltimore Council case, which was on the Bill of Rights application of the states. They first say, the federal government of Washington has this inherent sovereign right to take property. Notwithstanding that there's a provision in the Constitution that says the only way they can take property is with the permission of the state legislatures. I mean, all you have to do is read that and say, well, that's inconsistent. That is certainly inconsistent with the idea that the government can take any property, the national government can take any property they want through eminent domain. Why is this thing in here about requiring the consent of the state legislatures? If the national government has the power of eminent domain, then it doesn't have to consult the state legislatures, which is what it's doing now. Should go all the way back to some of these so-called founders of the country. Marshall, I think, was one responsible for that, John Marshall. I said, well, this is complete nonsense, but it's way back there in the bowels of the Supreme Court archives. And I have yet to hear someone in the modern world in one of these cases come out and say, wait a minute, there's an inconsistency here. This whole line of eminent domain cases is bunkum, because if you trace it back, you'll see it's inconsistent with the provision of the Constitution, which requires the opposite. It's totally impossible to have eminent domain on the one hand and then require Congress to seek the consent of a state legislature to exercise that power. Which is it? Well, it would have to be the consent of the legislature of the state would control, because it's written in the Constitution. But there it is. And so now we're in the position where potentially you can have these foreign entities, the World Health Organization, which is not even it's not even the Security Council, right? The most important things come in front of the Security Council. War, for instance, in which what? The United States has a veto. Every one of the Security Council members, the major members, have vetoes, right? This is something that's coming out of some lower level agency. Who is Boutros Ghali? Who elected him? You see? So this is where this whole process has gone. And in a sense, Klaus Schwab is right. And it's not in the future, it's right now. Right? You will own nothing. Because your ownership interest, and I think he's using the wrong word there, right? But because I may not own, an apartment that I'm living in. I own the lease, I suppose. Maybe he's talking in that sense, general ownership. Right now, it's probably the case that you don't own anything. If one of these false doctrines is laid on the table, right, and the myrmidons of the state come up armed, better armed than the infantry of both sides of the Battle of Stalingrad, these guys showing up. And they say, well, you're going to be evicted, taken out of here, because what? We've decided to take this land over for a hotel. City council and we're giving you what? The last real estate value of, even though as soon as the hotel is built, the land will be worth 100 times more. We're giving you just a 1% value because we can decide what's fair market value. All right? Oh, goodness gracious. And of course, many years ago, I tried to get a case going to get to the Supreme Court, which raised this whole question of just compensation, tying into the money situation. Wouldn't just compensation have to be calculated in the kind of money that the United States was using when the Constitution was ratified, or the Bill of Rights were ratified? Well, what kind of money was that? Well, U.S. dollars. What's a U.S. dollar? 371 1/4 grains of silver. We know that from the first coinage act, Mint Act, 1792. So that was the question, and it was peculiar how it came up. But in any event, it was a reverse condemnation. We were requiring the state agency to condemn this piece of land because of the way it was being used, or couldn't be used, or should have been taken, whatever. And so we go into court and say this should be. We want the jury to calculate the value of this property in silver dollars. Not that we wanted the value in paper money and then paid in silver dollars, which would be an increase in the real economic value, but just calculate it in silver dollars. So it might be $10,000 in Federal Reserve notes, but it might only be $6,220 calculated in silver dollars. We wanted just the economic value, not a windfall, right? Because that's the method of just compensation, to be paid in constitutional money. Think the courts wanted to hear that one? No. I mean, lose at every level. They didn't want to touch that with a 1,000,000-foot pole, because it would bring you back to this question, not simply of just compensation in the terms of economic value, but the money question. All right? So you got fraud on every kind of level you can imagine in here. And that's why I say, shrug your shoulders, you have to go back to Benjamin Franklin. It's a republic if you can keep it. Well, you haven't kept it. What do you expect? And now you have a rat's nest, you have a Gordian knot, which is probably impossible to unravel. If you think of all the unique steps that would have to be taken in terms of each different agency at the national level, at the state level, and the local level, whatever, statutes that would have to be passed to unravel this mess, how long would that take? What kind of expertise would you need in a legislature to be able to figure out how to do that? And not just one sitting of a legislature for 2 years or 4 years, a state legislature or Congress. You might have to do this over 3 or 4 sessions of a legislature. 12 years, 16 years, who knows how long it would take. It's taken what, 200 years to get here? So you can imagine. Now, some things would be easy. The forfeiture laws would be easy. The eminent domain law, public use versus private use, would be easy. Just make that a criminal violation, that's all. End of discussion. Attempt to do that. Make it a criminal violation of these forfeiture laws, forfeiture seizures. Stop that right away. But if you get into all the regulations that have control elements built into them over the use and enjoyment of personal property, now you've got to take those apart piece by piece. And in some cases, they're like a game of jackstraws. You know, you pull one out without disturbing the rest of the pile because they're parts of other more complicated statutory structures, which you can't eliminate all at once. And so it becomes a very careful situation of sort of balancing what you're doing in this particular amendment or this particular change. And then, of course, you got the whole problem of the regulators, because no sooner will you take some power away from a regulator, they'll find some other way to exercise that same power. That's another game. You have to go after the whole administrative state in many instances. And in the Environmental Protection Agency area, that thing would have to be, literally gutted. There's so much that they're doing, they're just out of bounds. Well, who's going to do that? We come back to this. Who is going to do that? And the answer is, well, it's not your Congress not going to do that. And the state legislatures can't do it at the level of Congress. And let's take an example. I think you mentioned this when you put Governor Abbott there in Texas. And he has a situation. It's called an invasion.
This is Kaiser Johnson with Liberty and Finance, and these are the Miles Franklin Weekly Specials for January 29th through February 5th, 2024, while supplies last. This week we have silver Valcambi or Asahi 100-ounce bars at just $1.39 over spot per ounce. We also feature pre-1933 gold $10 and $20 Liberties at $89 over melt and $139 over melt, respectively. Next, backdated 1-ounce silver maples are at $3.75 over spot with a minimum order of 50. To order our specials or any of the many other options we have available, call us at 1-888-81-LIBERTY. That's 1-888-815-4237. We're available after hours and on weekends, and we look forward to speaking with you.